recent changes to the rules, as Jim mentioned. There's been a couple of recent immigration acts come through in the last couple of years. Your responsibilities under the law as employers, who you need to check documents for and what you need to check, going through a few of the acceptable documents you're likely to see, when you need to be carrying out those checks, how you need to be carrying out those checks, and some of the typical endorsements you're going to see as to whether someone has the right to work or not. So the recent Immigration Act 2016 came into force just a few months ago. It's always been an offence to knowingly employ someone illegally, but they've recently broadened this in the latest act to having reasonable cause to believe that the person doesn't have the right to work in the UK. So this is just an example of the Home Office tightening their approach to illegal working, creating a hostile environment for people who don't have the right to be here, and it just means further responsibilities for you guys. The current civil penalty regime has been in force since May 2014. It was originally introduced several years earlier, but they made a number of changes in 2014 to the document types you can accept and the timing of the checks you need to be carrying out as employers. There are copies of the new and the old guidance available online at the link on the screen, and I understand the slides are going to be shared later, so you'll have that to refer to as and when you need to do that. So there have been various regimes for preventing illegal working in place since 1997. Originally, it was just a criminal sanction for employing someone illegally. In 2006, the Immigration, Asylum, and Nationality Act came in, and that actually came into force in a couple of years later in 2008 and introduced civil penalties. Originally, it was a civil penalty of up to £10,000 per illegal worker, and in the Immigration Act 2014, that was doubled, so it's now £20,000 per illegal worker. The changes between the original 1997 regime and the one that came in later also changed the timing of checks and introduced the need to be doing repeat checks as and when you needed to for people who had limited status in the UK. This is the wording of the Act as it is at the moment, Section 15 of the Immigration, Asylum, and Nationality Act. It makes it an offence to employ someone subject to immigration control if they don't have the right to be here, or their leave is invalid, has expired, or is subject to a condition that prevents them from taking the employment in question. Section 3 that you see on the slides is what we're talking about today. That says that an employer is excused from paying a penalty if he shows that he has complied with any prescribed requirements in relation to the employment. So that's what we're looking at today. We're looking at those prescribed requirements, the checks you need to be carrying out, and how you need to do that in order to establish a statutory excuse so that if you do accidentally employ someone illegally, you don't have to pay that £20,000 fine. So who do you need to be checking? You always need to be checking in documents for employees. In the case of agency workers, if you're just talking about temps who are provided to you by a high street agency or something like that, and they're actually employed by the agency, they're not your responsibility, they're the agency's responsibility. So you don't need to be checking documents for them, although it is often worth getting an indemnity from the agency confirming that they've done their checks. If the agency is acting as a recruiter for you, and then you employ the individuals directly, then you will need to carry out your own checks. You won't be able to rely on the agency having done those for you. In the case of contractors, self-employed people, you only need to worry about them if an employment relationship arises. If they are 100% self-employed, they issue you invoices on a monthly basis, they're working for you and a dozen other people, then they're not your responsibility. They're not employees and you don't need to worry about them. If, on the other hand, you've got someone like your casual workers that Jen mentioned earlier, then you would need to worry about them. You would need to check their documentation because sometimes a quasi-employment relationship can arise. These guys are paid through your own payroll, so you guys should be checking their documents. If you're ever in any doubt about whether someone needs to be checked, contact HR. They'll be able to clear it up and decide whether the person needs to have their documents checked. As ever in UK employment matters, it's always important not to discriminate. There is a code of practice published on the Home Office, the UK Visas and Immigration website, about avoiding discrimination while conducting these processes. As a general rule, everyone needs to be treated the same. You can't be treating someone differently because this person looks and sounds British and this person looks and sounds foreign. Everyone needs to be treated the same to avoid discrimination. So what do you actually need to be checking? It's always worth going back to the Home Office's original guidance and making sure it is still current. It does change from time to time. As I mentioned, the last big changes to this process were made in 2014. So it is a good idea just to make sure that you're looking at the most up-to-date version. There are, broadly speaking, two types of documents you're likely to see for these checks. There are List A documents, which the Home Office includes on a list of people who have the ongoing right to work in the UK. Usually that will include people like British citizens, EEA citizens for the time being, subject to Brexit and any changes that may bring, and people with indefinite leave to remain in the UK or permanent residence. They've got an ongoing right to be here. You check their documents and then you're done. They've got the right and they've shown it and you don't need to worry about them anymore. List B documents are for people who have a limited right to be here in the UK. For example, they're here as a sponsored worker, they're here as a student, or they're here as a spouse of a British citizen or something like that. They will often have time limits on their amount, on how long they can be here, and often they will have other work restrictions as well. So with those people, because they're not able to stay here forever, you'll have to follow a different process. You'll have to do additional checks for them as and when the time comes. As I mentioned, there were some significant changes in 2014 to the process, which is why it's always a good idea to go back to the original, make sure that nothing else has changed. They reduced the number of acceptable documents that you can take for this sort of thing, but they made the process slightly easier as well in terms of the documents you needed to copy. In some cases, you do need to have extra documentation, though. So if someone presents you with a student visa, for example, often students will be able to work part-time during term time, often 10 hours a week or 20 hours a week, depending on what level of course they're studying and where they're studying it. Outside of term times, during vacations and between the end of their course up to the expiry of their visa, students can usually work full-time. So if someone comes to you and they've got a student visa and they want to work full-time, you're going to need extra evidence as to those term dates in order to do that. As I say, with List B documents, these are the ones that show someone has a limited right to be here. When the 2006 regime was brought in and the civil penalty regime was first introduced, you needed to do these checks every single year, even if that meant you were checking the same document 3 or 4 times. Now they've changed that. You don't need to check it every single year, but you still do need to do repeat checks so that when someone's leave is expiring, you make sure they've got new leave or they've got a permanent status or something like that. List B is split into 2 groups. Group 1 is where you ask someone to give you a document and they give you a document, and that shows they've got current leave, leave to remain in the UK, and that leave to remain allows them to do the work you're offering. You check that document and then you diarize a date for the future when that's going to expire to arrange your repeat check. Group 2 documents are where they don't have a document to show you because they've got an outstanding application with the Home Office. They've submitted their passport and their existing visa to the Home Office to be renewed, so they don't have anything to show you. Where that happens and they've made an in-time appeal before their visa was due to expire, and that visa allowed them to do the work in question, then their status should automatically be extended in the meantime and they should be able to work. But in order for you guys to confirm that, because you haven't got any documents, you need to get a positive verification notice from the Home Office, from their employer checking service. If someone comes to you in this sort of situation, what you'll need to do is contact HR. HR will contact the employer's checking service for you, and they'll get the positive verification notice for that. So, the documents you're likely to see, starting off with List A, these are the ones that have the permanent right to work in the UK, so you only need to check the documents once before the person starts work, and then you don't need to check it again in the future. Obviously, the main one you're going to see, the most common one, is going to be a British passport. These have changed over the years, as most of you will know, from the old style blue passport to the more recent red ones. What you'll need to do when you're checking these is make sure that it is the passport of a British citizen. Because of the history of the UK and the Empire and the colonies and all that sort of thing, there are a number of residual types of British nationality out there due to ties with the former Empire and the former colonies. For example, you will sometimes see British overseas citizens, or you might see British nationals overseas who had ties to the Hong Kong territory while it was under British control, or you might see British overseas territory citizens. Out of all these, only British citizens have the right to live and work in the UK. So if you see one of the other types, they may not have the right to work in the UK, and they may need separate authorization to do that. So if someone presents you with a British citizen passport, that's an acceptable List A document, and you can employ them in the UK without doing any further checks. A certificate of entitlement to right of abode. This might look like either of the two options you see on the screen in front of you. It must be in a current valid passport. If you see one of the ones on the right-hand side, which looks like a standard visa sticker, it will usually have an expiry date on it, which is the same as the expiry date of the passport. If they show you one on an old passport, they're going to need to get a new one to show you the new endorsement. Right of abode is, generally speaking, something that all British citizens have. Not many people who aren't British citizens already will have it. Some Commonwealth citizens, depending on how they were involved with the UK before their country became independent, they will sometimes have it as well. EEA and Swiss citizens, for the time being until Brexit happens and changes everything, have the right to live and work in the UK under free movement rules. So if someone presents you with a EEA or Swiss national passport or national ID card, that can show that they have the right to work in the UK. You will need to check that it does show that they are a citizen of the country in question, because some countries do issue ID cards and so on to residents as well. So you should check that it is a EEA or Swiss national ID card rather than just residents. Croatians are members of the EU. They are EEA nationals, but there are currently restrictions on their ability to work in the UK. So if you do find someone who presents you with a Croatian passport or something like that, you'll need to contact HR for additional guidance on what they need to provide to show they can work here. Obviously, with the number of different passports and ID cards out there under the in the European Union and the European Economic Area, there are loads and loads of them, and you won't be expected to know them all off by heart. You could see any of them. There is an online register called Prado. The link is on the screen and will be in the slides that get sent to you. So you can look that up if you see one you haven't seen before. Just make sure it is of the style that it should be, and it's not completely different to anything that's issued by that country in question. Staying with EEA and Swiss nationals, when they arrive in the UK, they can apply for a registration certificate, and once they've been here for 5 years and they get permanent residence, they can apply for a document certifying permanent residence. These look like the items you see on the screen at the bottom there. They're a long piece of card which folds into 3, and there will be a sticker on it, an endorsement, showing the details of the person and their status in the UK. These are not mandatory documents. EEA and Swiss citizens, when they arrive in the UK, don't have to apply for these, but they can do so if they want to. So if they present you with one of these, it'll show what their status is. But if they don't have one of these, it doesn't necessarily mean that they're not having the right to work in the UK. So you just need to be a little bit careful with that. EEA and Swiss citizens can also bring their family members to the UK. So if someone presents you with a card showing that they've got permanent residence as the family member of an EEA or Swiss national, that can be acceptable evidence of their right to live and work in the UK. In the same way as EEA citizens, once they've been here for 5 years, can get permanent residence, their family members can as well, and they can apply for this as evidence of that. The sticker you see there, it may be endorsed in different ways. Often it's going to be endorsed in a passport, but sometimes you'll see it endorsed on a separate document called an immigration status document, which we'll see an example of just shortly. Biometric residence permits, or BRPs, are one of the more common documents you're going to see now. After a British passport or an EEA passport, this is probably going to be the most common document you're going to see. They're issued for just about everything these days. In this case, because we're looking at List A documents with permanent right to be here, we're looking at one that says the person has the right to stay here indefinitely, or they have no time limit on their stay, or they've got a settlement. If they show you one of these, you need to copy both sides of it, but that's an evidence of their permanent right to live and work in the UK. The card itself will have an expiry date on it. It's like a UK driving license like that, where it needs to be renewed every 10 years or so, because our parents might have changed or something like that. But even though it's got an expiry date on it, if it says they've got an indefinite status or no time limit or settlement, they'll have the ongoing right to be here in the UK. They may present you with a passport, which is endorsed to show that they have indefinite leave to be here or right of abode or no time limit and so on. This may take one of several forms. It may just be an ink stamp, like you see on the left-hand side, issued by an immigration officer at the port of entry. It may be one of the old-style green stickers in the center, or it may be one of the residence permits on the right-hand side. If you see one of these, it needs to be in a current passport for you to accept it as right to work in the UK. If it's not in a current passport, then the person will need to apply for one of the biometric cards we saw on the previous slide. An immigration status document is a separate piece of paper, really. It's just an A4 piece of paper normally that folds down into 4 and has different information on each of the quarters. So it'll include information about the person. It'll include a sticker with an endorsement on it. This may be the permanent residence card for EEA family members that we looked at earlier. It may be something else. If they show you one of these showing they've got indefinite status here, or no time limit, and they can show you a national insurance number document as well, you can accept that as evidence of their right to work in the UK. Alternatively, they may be able to show you a full UK birth certificate or adoption certificate, and again, a national insurance number document. When they're talking about a full UK birth or adoption certificate, they're talking about the one that shows the names of both parents. It wouldn't be the short version, which only has details of the child born in the UK. It needs to be the one showing the parents' details as well. You may also see Channel Islands birth certificates, or Isle of Man birth certificates, or Irish birth certificates, and you can accept those along with a national insurance number document as well as evidence of the right to live and work in the UK. Citizenship certificates, whether a registration as a child or a naturalization as an adult. And again, if they show you one of these showing that they are a British citizen together with a national insurance number document, then you can accept that as evidence of their right to work in the UK. When they're talking about a national insurance number document, they're talking about an official document giving the person's permanent national insurance number, so not one of the temporary national insurance numbers, and their name, issued by a government agency or a previous employer. Usually that will be something like a P60 or a P45 or one of the national insurance number cards. Sometimes you might see a letter from the job centre or DWP issuing them a national insurance number. Moving on to List B now. List B was the group of documents which show that the person doesn't have the permanent right to be here, but shows that they can be here for the time being and do the work in question. So you might be presented with a current passport with an endorsement in it showing that they can do the work. We see some examples here. The two at the top are residence permits issued in the UK, and the one at the bottom is an entry clearance or a visa issued outside the UK. You may be able to see on the one at the bottom that's a bit larger, it has an endorsement on it that says no recourse to public funds, work and any changes must be authorized. So this is a visa that includes the right to work in the UK, subject to authorization. As before, these endorsements need to be in a current passport. If they present you with an endorsement like this in an expired passport, then they need to make a separate application to replace that with a biometric residence permit. As biometric residence permits are the most common document you're going to see other than British passports or possibly EEA passports at this stage. They're issued for almost everything. If a person applies for a visa to come to the UK that's longer than 6 months, they won't be issued with a visa for the full validity of their stay. They'll just be issued with a 1-month entry permit to get to the UK, and then once they arrive, they'll have to collect a biometric residence permit from a nominated post office. So the biometric residence permit itself, again, will have issue date and expiry date, so you can see how long it's valid for, and will have conditions on it detailing what work they can do, what their status is, and so on. As I mentioned earlier, EEA and Swiss citizens can bring their family members to the UK. Up until the point that they've been here for 5 years and they get permanent residence, their stay would be dependent on their EEA family member being here and exercising treaty rights as a worker or something like that. So they can apply for evidence of their right to be here for the time being, but it's limited because they haven't got permanent residence yet. So if someone presents you with a current residence card, including an accession residence card for people like Croatians and so on, or a derivative residence card for people with particular ties to certain types of EU citizens, then you can accept that as evidence of their right to be here and right to do work that is permitted on the endorsement itself. The document you see on the right-hand side of the screen is an EEA family permit. Those are issued to people outside the UK, and they're usually valid for 6 months to allow the person to travel to the UK to accompany their EEA spouse or partner or whatever. The document on the left-hand side is the residence card, and that is what they apply for once they've arrived in the UK. And that's usually valid for 5 years, which would normally be enough time to get them to permanent residence. Again, they may present you with an immigration status document rather than a passport. As long as it contains all the right details and it's got the right sort of endorsement on it showing they can do the work in question. For example, it might be an immigration status document endorsed with a residence card like we saw on the previous slide, and they present you with a national insurance number document, then you can accept that as evidence of their right to live and work in the UK. When an EEA family member makes an application for their residence card in the UK, they should be issued with a certificate of application. That certificate will confirm that their application is with the Home Office and will include confirmation for employers as to whether or not the person can write and work in the UK. There is a slight distinction between family members of EEA and Swiss nationals and extended family members. Family members include children and spouses and things like that, and they are automatically allowed to live and work in the UK regardless of whether the Home Office says they can or not. So when they apply for their card, the certificate of application will normally include a confirmation for the employer that the person is allowed to take employment. Extended family members includes people like unmarried partners and fiancés and so on, and they don't have the automatic right to live and work in the UK unless the Home Office says they do. So the confirmation that's on the certificate of application for extended family members will often say that they don't have the right to work until they get a decision. The certificate of application you're looking for from prospective employees is the one confirming they can take employment. In addition to that, you will need the positive verification notice from the Employers Checking Service. You'll need to get pass this across to HR as and when required, so that they can contact the Home Office Employers Checking Service and get confirmation that an application is still outstanding and that the person does have the right to work in the meantime. Application registration cards are issued to asylum seekers and refugees in the UK. Sometimes these will include confirmation that the person is allowed to work in the UK or employment is permitted, but not in all cases. If you are presented with one of these showing the person can work in the UK, again, you'll need to refer this across to HR because they will need to get confirmation again from the Employers Checking Service and a positive verification notice confirming that an application is outstanding and the person is able to work in the UK. Speaking about the Employers Checking Service, this is what the website looks like on the right-hand side. It includes information about the details you will need to make the request. Usually these will be passed across to HR so they can do it for you, but in case you ever need to do it yourself, that information is there. And the positive verification notice itself is seen at the bottom left of the screen here. You can see it at row 2, it says the person has the right to work subject to any restrictions in section 4, in which case there are none here. Here are some of the unacceptable endorsements you are possibly going to see. These do not show that the person has to live and work, the right to live and work in the UK, and you wouldn't be able to employ them on the basis of these endorsements. In the upper left, we see a number of black and white just ink stamps that will be issued by an immigration officer at the airport as the person lands in the UK. And generally speaking, these will include a time limit of 6 months if the person is coming as a visitor, and a restriction saying employment and public funds are prohibited. So they can't work and they can't claim benefits. If the person is a nationality that isn't able to travel to the UK without a visa as a visitor, then they would need to apply for this before traveling to the UK, and that is the document you see at the very bottom of the screen, bottom left. These again will have information about the person's status, in this case a C visit visa, and will have restrictions on it saying no right to work in the UK. As I mentioned about the application registration cards for asylum seekers and refugees, sometimes they'll have the right to work in the UK and sometimes they won't. So you may be presented with one of these saying that employment is prohibited. And on the right-hand side, we see an employer's check and service confirmation that a negative verification notice in this case confirms the person doesn't have the right to work in the UK. When you need to check the documents, the checks need to be carried out before employment begins. The reason for this is that if you have them come in on their first day and check the documents as part of their induction or something like that, you could be employing them illegally for 20 or 30 minutes without realizing it. So it's important that the checks are done before the person starts work in the UK. And I think I'm handing across to Jen to talk about your particular processes here.
Thanks, Ross. With the candidates, when they are invited to interview by the HR team, whoever you're working with on your recruitment, they will actually be asked to bring their right to work documents in the invite to interview email. Now when they actually get to you and they come in for their interview, whoever it is, the receptionist or the trained person, will need to take a photocopy of the document. Now that actually needs to be a colour photocopy. And it's really important that they actually write on the document to say that they've seen the original document itself, sign it and date it. Now that needs to be scanned and then emailed across to the HR admin email address. Now once it's been sent to us, if you can then delete it from your system. Now we don't expect you to be immigration specialists, so if you've got any questions, any queries, or you're not sure about the documents that have been brought in, please let us know and we'll follow up with all of those documents and answer any questions that do come up from them. Okay, thanks, Ross.
Okay. So how long are the checks valid for? List A documents, they show the person has a permanent right to live and work in the UK, so you only need to check those once, and that is valid for the duration of the employment as long as they work for you. List B documents, showing the person only has the right to be here for a limited amount of time. If you're shown a Group 1 document, you're shown evidence they have the right to be here and it's got an expiry date on it. That will be valid for the duration of that endorsement, the duration of that visa. When they come to the end of that time, either the person will have applied for permanent status and will then have a List A document they can show you, or they'll have another List B document because they've done an extension in the same category or something like that. Or if they've got an application that's still outstanding, they haven't received a decision yet, they haven't received their new endorsement, they'll be able to, you might need to follow the Group 2 process. Group 2, that's where the person has the outstanding application and you need to refer that case to HR, and HR will contact the employer's checking service and ask for a positive verification notice. If they get a positive verification notice, that's good for 6 months, and the person can work for you for those 6 months. It's going to be rare that an application takes longer than 6 months. It does happen from time to time, but if it does happen, HR will just need to get a new positive verification notice confirming that the person can still work in the UK. So how to actually make the checks. You need to take a copy of the relevant page or pages. So for passports, you'll need the biometric photo page and any pages containing visas or residence permits. In the case of biometric cards, you'll need to take copies of both sides of the card because there's important information on both sides. If you're presented with a List B document, you'll need to note the expiry date and arrange for repeat checks. You'll need to be checking to see if an employer's checking services inquiry is required, in which case you need to refer that to HR so they can make the check. You need to be noting any particular restrictions on the visa. For example, the number of hours and the type of work they can do. For example, students are only able to work part-time during term time and full-time during vacations and after the end of their course. And you need to make sure that the work that they're doing isn't going to breach the conditions on their status. Just a reminder of what we mentioned at the beginning is knowingly employing an illegal worker, or more recently, having reasonable cause to believe that the person didn't have the permission to work in the UK, is a criminal offence, and it doesn't assist you to do any of these checks in that sort of situation. So all of this is aimed at when you inadvertently employ someone illegally and you had no way of knowing they were, then you can have a statutory excuse against paying a civil penalty. If you know full well that the person isn't able to work here, you know full well they've given you a false passport or something like that, then this doesn't protect you and you could be criminally liable. That said, the Home Office doesn't expect you to be experts on forged documents and false documents. You just need to take all reasonable steps to satisfy yourself that the document is genuine and valid. For example, you'd be looking at the document and holding it up next to the person's face and satisfying yourself that the photograph is of the person in front of you. You'd be looking at dates of birth and making sure they're consistent across different documents. So if they give you a national insurance number document and a birth certificate, is the date of birth consistent, and does it match their appearance? Is the person looks like they're 60 or 70 years old and they're giving you the birth certificate or a passport of a 20-year-old. If they have limited leave to enter or remain in the UK, is it still valid or has it expired? What are the work restrictions, and do you need additional evidence of term dates if the person is going to be a student and working? Are you satisfied the document is genuine and has not been tampered with? For example, is the plastic cover on the photo page peeling off? Does it look like the photo has been replaced with someone else? Are the names the same across the different documents? And if they're not, is there a reason for this? Has the person got married? Have they got divorced? Have they changed their name by deed poll and present you with evidence of this? As I say, the Home Office doesn't expect you to be experts. You just need to take any reasonable steps to ensure, satisfy yourself that the document is genuine and is of the person in front of you. As I mentioned, with students, they may have permission to work in the UK, depending on what the course they're studying, what level, and where they're studying it. They may have restrictions on the number of hours they can work during the week, often 10 hours a week or 20 hours a week, but they can work full-time outside of term time and between the end of their course and the expiry of their visa. If one of them does want to work full-time, then you'll need evidence of their term dates. For example, a printout from the university's website showing the term dates, or a letter from the university or the college confirming the term dates. If you need something like this, then you refer the case to HR, and HR will make those inquiries for you. The right to work for students is contingent on them following their course of study. So if they do drop out, they wouldn't any longer have the right to live and work in the UK. Again, looking back to the reasonable cause to believe the person doesn't have the right to work here, if it comes to your attention that the person has dropped out and is no longer studying in the UK, and therefore has no right to work here, you could be looking at a civil penalty or a prosecution for that under the reasonable cause to believe idea. When you're checking the biometric cards, you should obviously just check it's clean, it's in good condition, doesn't look like it's been tampered with. The biometric cards are very similar to a photo card driving license. They're a little bit thicker. The permit number in the top right always follows the same format. It always starts with 2 letters. The third character is either an X or a digit, and the last 6 characters will always be digits. It's not raised, so you should be able to run your finger across the permit number and not feel anything. But there are other tactile features on the card that you can run your finger across and feel them. The photograph as well will always be in grayscale. It'll never be in color. And then finally, just looking at some of the typical endorsements you're likely to see on biometric cards, as they're the most common thing you'll see other than the British passport. They're endorsed in a variety of ways. They're not always that consistent about it, but typical ones would be either just saying work permitted, full stop, or no work, again, full stop, they're both categorical. Sometimes it'll say work restricted, in which case there are particular situations in which the person can or can't work. And the card will either expand on that or you need to refer to HR, and it'll depend on the type of visa they've got. In the case of students, again, it'll include right to work, but subject to a maximum number of hours in term time often, so 10 hours a week or 20 hours a week. And the final example we've got here on the screen is something you'll see a lot for family members of points-based system migrants, is no doctor or dentist in training or professional sports person. In all cases, as Jen said, HR doesn't expect you to be immigration experts, so when you get to the documents, you're going to be sending them across to HR anyway. Refer all the scanned copies of the biometric cards to HR, and they can determine whether the person has the right to work or not. Okay, so we've come to the end now. So if anyone does have any questions, I haven't seen any pop up in the chat box on the right-hand side of the screen. You can either stick them in there, or if you wanted to email HR afterwards, then HR or myself can answer those questions.
Great, thanks very much, Ross, for your time, and thank you everyone for listening in today. Hopefully you have taken something away from that. And yeah, as Ross said, if you've got any further questions, please don't hesitate to direct them to the HR department. Thanks everyone. Have a great weekend.
Thank you very much. Thank you.
Thank you.
Thank
Bye-bye.
you.
Bye-bye.
Thank you.
Bye.